All right, this is a sound check for Alejandro in CC3 and 5 for the hearing board, Thursday, August 17th, 2017. For emergencies with the potential to cause immediate harm or threat or property damage, call 911. When using SCAQMD hardline phones, the prefix is 9. This is a test for Alejandro in CC3 and 5, and I'll keep talking here until you come around the corner and let me know this is okay. And this is Thursday, August 17th, 2017. We're at the South Coast Air Quality Management District headquarters in Diamond Bar, California. We have some like rules and regulations or order of the board what to read, and we have like a standard paper. You know, I had an agenda, just anything.
You want to read a petition?
There you go. Thank you. Oh, we're good? Okay, thanks.
Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. It is Thursday, August 23rd, 2017. We are meeting in the Hearing Board in Diamond Bar. The time is almost 9:05 a.m. And we have only one matter to hear today on calendar. That is AQMD versus Loopco, case number 6089-1. Who is representing the district today?
Teresa Barrera and Stacy Pruitt on behalf of the Executive Officer.
Thank you. And who is representing Loopco today?
Christopher Foster.
Thank you. Ladies and gentlemen who are here today, the purpose of this hearing today is to consider the petition of the AQMD for an order for abatement against Loopco. In particular, we have received, although we have not had an opportunity to review quite yet, a stipulated order for abatement, which means that the parties have agreed upon conditions. As I understand, there is still at least one issue that remains unstipulated. They are asking us today to begin to consider the stipulated order for abatement. And I'm hoping that copies, I know Ms. Pereira, you were saying that there was a glitch. Have copies been made available?
Yes, they are out front.
Okay. Copies are available out front if anyone in the public would like to see copies of both the stipulated order for abatement, and in addition, the parties have decided to, for the most part, proceed by declaration, and copies of the declarations also are outside, I believe.
That is correct. And because we did not actually reach final agreement on every issue with respect to a stipulated order, to the extent the public is looking for that order, it is attached in the exhibits as Exhibit 16. And again, up front, I will just say that it is Attachment 1 to that order that is the source of dispute, but the order itself is what we have agreed to.
Okay, so the attachment to the order which is found in exhibit, we'll mark it as Exhibit 16. Is that correct?
Yes, it is Exhibit 16. And just, you said Attachment 2. There are two attachments to the order. It is Attachment 1 of that order that is the source of the dispute. Attachment 2 to the order is not in dispute.
Okay, that's the diagram.
Correct.
Okay, thank you. So the parties have asked, again, to proceed by declaration today. So how we plan to proceed is we're going to start with opening statements, first by the district, then by Loopco. Then we're going to take a considerable amount of time as a break, perhaps up to an hour. I'm not sure how long board members will need in order to take the time to review both the proposed order as well as the declarations that have been provided. Then we will come back and we're going to take public comment. So any member of the public who wishes to be heard today on this matter can be heard at that time. And it would be best if members of the public do wish to be heard to be most relevant, again, to review the papers that are outside and available to the public so that your comments can be considered by this board as evidence and they are relevant to the stipulated order that has been proposed and the declarations that have been made and the evidence presented in this case. So let's start with the preliminary matters. We have before us a packet entitled District Exhibits, and they are 1 through 16. So let's begin by marking those exhibits as they are already tabbed and marked 1 through 16. In addition, we have another packet which is entitled District Declarations in Support of Stipulated Order for Abatement, and there are several declarations that are attached. Let's mark that entire packet as Exhibit number 17 for the district. And finally, I see that we have one declaration of Steve Rossi, and that is going to be marked as Exhibit A for Loopco. And are there any other preliminary matters that we should get out of the way before we move forward with opening statements? Let's start with Ms. Pereira.
No, I think I prepared it.
Oh, sorry, Dr. Lerner.
Just have a question.
I'm going to ask, Mr. Foster, Exhibit A has attached to it the proposed findings and decision. I assume that's the same proposed finding and decision that is also attached as Exhibit 16 for the district. Is that correct?
It is not correct.
It is not correct. Oh, that's right. You have a separate.
Attachment 1 to Steve Rossi's declaration is a list, essentially presented to show a list of the modifications to operations and processes that LUBCO has agreed to as part of the stipulation. So the language of what's Attachment 1, proposed findings and decision on petition for order for abatement, is not identical to the stipulation.
So the only difference is Attachment 1, is that correct?
No, the entire document has some minor differences with the stipulated order that the district has presented.
Okay.
There was a little miscommunication between council about what was going to be presented to the board, and what is presented in Mr. Rossi's declaration was meant only to cover those items and processes and operations and modifications to which LUBCO had agreed. So there's some tiny minor differences between the two, and the stipulated is the one presented by the district.
Okay, so what we will do is, if I can ask the parties to please explain that in your openings. Ms. Barrera, did you have something to add?
That's fine. He can explain that in his opening. The district has not, the one that the district has presented in Exhibit 16 is what the district is prepared to stipulate to. As I understand it, one of the things that he pointed out is more of frankly, an editing type of thing, and I would have to check with the engineers, but I suspect that's not a big deal. As to the other ones, I could not agree at this time.
Okay.
Okay.
Fair enough. So we'll hear that more fully upon opening. Since we're doing this by declaration, I'm not going to ask witnesses to be sworn in at this time. Instead, I'm just going to ask Ms. Barrera if you can begin with your opening.
Thank you. Good morning, members of the board and members of the public. The district filed its petition seeking an order for abatement against LUBCO on July 21, 2017, less than 1 month ago. That petition alleged that LUBCO's emissions of hexavalent chromium are creating a significant risk of cancer for nearby residents, and the creation of that risk constitutes a nuisance. Even though the cancer risk is estimated on a 30-year exposure, the district nonetheless believed that it is compelled to act now. The risk to residents must be reduced now. As of today, LUBCO and the district have reached agreement on immediate, short-term, and longer-term measures designed to reduce LUBCO's emissions of hexavalent chromium. We also have reached agreement on detailed provisions relating to the curtailment of LUBCO's operations if hexchrome emissions measured at a downwind monitor exceed 1 nanogram per cubic meter. Although I wish I could state that we have agreed to everything, we have not. Unfortunately, the main source of disagreement pertains to the list of equipment to which the curtailment provisions will apply. Discussions on that issue are continuing. District Exhibit 16 is a draft of the proposed findings and conditions. Again, the parties have agreed to everything, and it's Attachment 1 to Exhibit 16 that is the source of the disagreement. That is the equipment list that would be subject to curtailment. Today, both the district and LUBCO are here to present evidence that good cause exists to order the conditions for which there is a stipulation. Again, that's everything in Exhibit 16, but for Attachment 1. For those members of the public who are not familiar with what a stipulated order is, I wanted to take some time to explain that. A stipulated order is designed to bring a facility into compliance through the imposition of immediately enforceable conditions. With a stipulated order, facilities do not have to admit that they did something wrong. The district is not required to prove that they did something wrong, and the hearing board's not required to make a finding of violation. The legislature created this mechanism in order to speed up the process of issuing orders. Extra days of hearings are avoided through stipulations. In addition, by lessening the number of hearing days, stipulated orders allow for the more efficient use of scarce district resources. LUBCO is not the only case being worked on by district witnesses. The issues of proof in these cases are extremely complex. To those who may worry that somehow a stipulated order may be a weaker order, I will say that the district does not agree to them unless we believe that they will protect the public and bring a facility into compliance. Ultimately, the district considers and pursues appropriate stipulated orders because we believe that the community benefits when compliance is achieved sooner rather than later. When an order is stipulated, the hearings board's task is to determine whether good cause exists to issue that order. In order to facilitate everyone's understanding and discussion regarding the evidence of good cause, both the district and LUBCO have prepared our testimony in the form of written declarations. I recognize that we're presenting both this board and the public with a lot of written information this morning. Thus, I'm going to take some time to summarize those declarations. When public testimony is then taken, I hope there will be a better understanding of what's happening in this proceeding. Upon completion of the public testimony today, we're proposing that we adjourn the hearing to next week. That will give everyone time, the board and the public, additional time to read and absorb the declarations and the exhibits and the proposed findings that we're presenting today. By next week, if the parties have not been able to resolve the Attachment 1 equipment issue, we will be prepared to present evidence and testimony on that issue. In addition, to the extent that the board has follow-up questions regarding the declarations, we'll endeavor to make witnesses available for those follow-ups. I'd like to just now talk a little bit about the declarations that we have submitted in support of our request for this order. The first declaration was prepared by Inspector Beverly Caldwell. Ms. Caldwell essentially sets the stage for this case. She will tell you that LUBCO is a metal finishing company located in the city of Long Beach. It is also directly across the street. It's on the border of Long Beach and Paramount, so across the street is the city of Paramount. She will tell you that she's been the inspector of LUBCO for 4 years, and during that time, she has consistently found them to be in compliance during her routine inspections. She also states, however, that there was not an ambient air monitor placed in the vicinity of LUBCO until May of 2017. Ms. Caldwell's declaration also discusses LUBCO's use of hex chrome in its day-to-day operations. These operations include 10 tanks which use hex chrome. They are not attached to any air pollution control equipment. And these are the 10 tanks that are set forth in Attachment 1 to Exhibit 16. Ms. Caldwell also discusses the specific layout of the facility in her declaration and the proximity of nearby residences to LUBCO. She took several pictures of the facility, and when I walk through the exhibits, I'll describe those photographs to you as she has described them. Ms. Caldwell also surveyed the surrounding area around LUBCO. She measured the nearest residence as being 75 feet from LUBCO. It's directly across Downey Avenue. Finally, based on the elevated levels of hex chrome that were measured by the ambient air monitor in May and June, as well as some additional evidence, Ms. Caldwell states that on June 30th, she issued LUBCO a notice of violation for nuisance. The district's second declaration is from District Engineer Hamid Mandalawi. Mr. Mandalawi is a permitting engineer familiar with LUBCO's equipment, operations, and permits. His declaration discusses how hex chrome is emitted in LUBCO's operations, and he identifies the conditions in the order which help reduce those emissions. The third declaration is from District Engineer Jason Aspel. Mr. Aspel has worked in the district's source testing division. His declaration describes how he participated in source testing of LUBCO's heated sodium dichromate tank. It's tank number 14 in April of this year. That testing revealed that tank 14 was emitting extremely high levels of hexavalent chromium. In particular, the emissions coming from that tank were found to be 4,000 times the levels measured in the most recent MATE study. And the MATE study is one of the ways that the district determines background levels in the district. The district's fourth declaration is from Jillian Wong. Ms. Wong is a planning and rules manager in charge of point source modeling. A model is a method of predicting how emissions from a source like LUBCO will be dispersed in the environment. Dr. Wong and her staff modeled the hexchrome emissions of LUBCO and determined that LUBCO is creating a cancer risk for the nearby residents of more than 400 in a million. The district considers any risk over 100 in a million to be significant. In modeling LUBCO's emissions, Ms. Wong used actual evidence of LUBCO's emissions, including the recent source test of tank 14. The district's fifth declaration is from the district's health effects officer, Joe K. Ghosh. Dr. Ghosh states that hexavalent chromium is a known human carcinogen. She also explains what some of the risk concepts mean. Finally, she states that if the levels of hexavalent chromium modeled by Ms. Wong were allowed to continue, it would increase the cancer risk and be harmful to public health. The district's sixth declaration is from Andrea Polidori, the district's atmospheric measurements manager. His staff installed the ambient air monitors around LUBCO, and he has concluded that LUBCO is more likely than not a significant contributor to the high levels of hexavalent chromium measured at monitor number 29, the most downwind monitor located immediately in front of LUBCO. Mr. Polidori also justifies why curtailment should be required whenever the downwind monitor exceeds 1 nanogram per cubic meter. The last declaration is mine, and I submitted it just to give you some background on the negotiations and to authenticate the findings and decision, the proposed order that we would like you to issue. I've separately provided you with a set of exhibits, and these exhibits are discussed in the various declarations. I can walk through them briefly. Exhibit 1 is basically an aerial map of LUBCO to orient you where this facility is. It's a single building facility. The residences, the numbers 29, 30, and 33 indicate where ambient air monitors have been placed. Monitors 29 and 30 are considered generally downwind, while monitor 33 is considered generally upwind.
Ms. Barrera, may I ask you, the hearing is being cast to video cast. Is it possible to put these up so that the public can also see what you are referring to?
Yes.
Thank you. Let's take a moment for that.
Okay. Once again, this is District Exhibit 1. Again, it's to orient everyone where LUBCO is located. The numbers 29, 30, and 33 reflect where monitors have been placed. The residents, where 29 is and 30, that is Downey Avenue. Where 33 is, that is 69th Street. The residents that Ms. Caldwell talks about in her declaration as being 75 feet from LUBCO are the ones directly across Downey Avenue, basically on the other side of where that reference to monitor 29 is. Also, again, the prevailing winds for the facility run from, are westerly, so they are coming from the left side or, of this map, from the west to the east. This is another map, aerial map of LUBCO, discussed by Inspector Caldwell in her declaration. It's a closer-up view of the building, of LUBCO's building, and the yellow marks on the building are the location of roll-up doors at the facility. Those doors are typically open when the facility is operating. This is District Exhibit 3. Again, it's described by Inspector Caldwell in her declaration. It is a photograph of the front side of LUBCO taken from Downey Avenue, and it shows the roll-up door on the front of the facility. This is District Exhibit 4. It is another photograph of the facility taken by Inspector Caldwell. This is the side roll-up door, a picture of the side roll-up door, which is on 69th Street and was taken by the inspector while she was standing on 69th Street. Okay. This picture is District Exhibit number 5. It is taken from inside LUBCO's facility by Inspector Caldwell. The door in towards the top of the photograph is the front roll-up door that faces Downey Avenue. And in the foreground of this picture are the process tanks that we've mentioned. Okay. This is District Exhibit number 6. It's basically another photograph of, it's very similar to Exhibit 5. Again, it shows the front roll-up door that faces Downey Avenue and also the process tanks. Okay. This is District Exhibit number 7. Again, a photograph taken by Inspector Caldwell. This is the rear roll-up door. It faces the back of LUBCO's building into their parking lot. And again, it's just shows the same process tanks, but from a different direction. This is District Exhibit number 8. This is another photograph taken by Inspector Caldwell and described in her declaration. She took it from 69th Street, and it's LUBCO's parking lot on the right there, and it's this shows the nearby residences that are located directly across the street. These are the ones that she measured as being 75 feet away from LUBCO. This photograph also shows the district air monitor on the telephone pole. There are 2 trees, and then the telephone pole is the right, kind of looks like a tree also, but it's actually the telephone pole. Looks like it's coming out of the roof of the blue car there. But you can see that is monitor number 29. Okay, this is District Exhibit number 9, another photograph taken by Inspector Caldwell and described in her declaration. She is taking it from Downey Avenue in front of Lubco, and it shows on the left-hand side there a nearby apartment building. It's Stonewood Apartments. Okay, this is District Exhibit number 10, another photograph taken by Inspector Caldwell. This is a photograph of the heated sodium dichromate tank, tank number 14. It has been, since these events have arisen, Lubco has covered this tank with plastic, and these are some interim measures that are being imposed, being made enforceable through the proposed stipulated order. So, and also it's the application of heat that also increases emissions, so there are conditions dealing with the use of heat on the tank. This is a copy of District Exhibit number 11, and it's longer than this, but so I'll show parts of it. But this is the notice of violation that Inspector Caldwell issued to Lubco on June 30th. Okay, this is District Exhibit number 12. This is another aerial map of Lubco. It was created by Jillian Wong to show where all of the residents are surrounding Lubco. The key, where's the key over here? Basically, residential areas are denoted by the color blue. There are also 2 schools which are near Lubco. They are denoted in yellow. The school to the right side of the map is sort of in the downwind direction. Lubco is noted on this map by the color orange. The remaining exhibits are not really, the visual part of them, I don't believe are as necessary to show. Exhibit 13 is a copy of the source test report related to the sodium dichromate tank that's discussed in Mr. Aspel's declaration. Exhibit 14 is an EPA information document regarding hexavalent chromium. District Exhibit 15 is a copy of the air monitoring results for all of the air monitors associated with our ongoing hexchrome monitoring in the district. At the top of the spreadsheets, you will see the site numbers, and again, the monitors around Lubco are number 29, 30, and 33. And then, as I've said before, District Exhibit 16 is the proposed findings and decision. In sum, I guess, that's it for the exhibits. The district offers these declarations and exhibits as evidence of good cause that the proposed order is justified. To the extent LUBCO and the district can't agree on which equipment should be subject to curtailment, we're prepared to present testimony next week so that you can resolve that issue for us. That concludes my opening statement. Thank you.
Thank you. Before I ask Mr. Foster for your opening statement, question to the parties. Is there any reason you can see why we should not, should we finish with public testimony today? Should we finish reviewing and get to a point where we can deliberate? Is there any reason why we should not deliberate on whether to adopt or grant the stipulated order for abatement with the exception of the 3 pieces of equipment that are in dispute, and then move forward with a modification next week to determine whether to include those as well?
The only thing is the couple of changes that Mr. Foster noted this morning that I have not had a chance to focus on, and I don't know if I will need to talk to staff about those. So before I could answer that question, we may have to take a break.
Well, we're going to take a break anyway for the board to review all the documents, so that might be a good time to do that. And when we reconvene, we can make that determination. Mr. Foster.
I'm not sure that we're going to be in a position to do that today, to ultimately determine what is in attachment 1. So you're talking about anything other than the inclusion of the equipment and tanks in attachment 1 that would be subject to the curtailment protocol.
My understanding was that there are mostly the equipment and tanks on attachment 1 were agreed upon with the exception of possibly 3 pieces of equipment. Is that correct?
That's correct.
Okay, so my proposal would be for the board to deliberate today and potentially adopt the stipulated order for abatement with the exception of those pieces of equipment that are in dispute, and then to come back to this board next week as was already proposed, but rather than waiting to adopt the order at that time, instead to modify it to include or not include those pieces of equipment.
Yes, that's acceptable to us.
Okay, and I understand from the district that Ms. Barrera is going to get back to us after speaking with staff on that. So, Mr. Foster, at this time, why don't you go ahead with your opening, if you would.
Thank you. Madam Chair, members of the board, in June of this year, the district issued a notice of violation to LUBCO for alleged violations of Health and Safety Code Section 41700 and District Rule 402. Section 41700 prohibits the discharge of air contaminants that, among other things, endanger the public. Rule 402 of the district essentially repeats the prohibitions in Section 41700. However, neither Rule 402 nor Section 41700 contains a standard or definition of what constitutes endangering. The district takes the position that endanger is synonymous with creation of a significant risk of harm. Further, District Rule 1402 defines a significant risk level for toxic air contaminants, such as hexavalent chromium, as a cancer risk of 100 in a million. Immediately upon its receipt of the NOV, LUBCO began an aggressive engagement with the district. LUBCO's aim was to identify and attack the cause, not the symptoms. That is, LUBCO wanted to address the emissions from its facility that the district alleged were in excess of the threshold of significance and thus could form the basis of a notice of violation pursuant to Rule 402 or Section 41700. In collaboration with the district, LUBCO developed a list of modifications and adjustments to its processes and operations to reduce emissions. These measures are detailed and described in detail in the declaration of Steve Rossi that was submitted to the board this morning. But in brief summary, they include cessation of the operation of Tank 23, a deoxidizer, Tank 24, potassium dichromate, and Tank 35, Dow-7. Covering all chromate process tanks with plastic when not in use. Conduct all demasking of chromate sprayed parts inside a spray booth. All paint trays used in painting parts with chromated coatings will be stored in an enclosed container when not in use. Conducting general maintenance using a vacuum vented to a HEPA filter. And finally, to address the emissions elephant in the room, connect the dichromate seal tank number 14, which is not currently subject to any district permitting requirements, to an air pollution control device. And until that is completed, subject tank 14 to a curtailment protocol. The inclusion of tank 14 in a curtailment protocol is the result of LUBCO's running the district's own risk model for all of LUBCO's current operations except tank 14, using emission factors from the district's source test of tank 14 and applying adjustments to the physical and chemical parameters of the other chromate process tanks. With tank 14 out of service, the remaining emissions are substantially below the threshold the district itself defines as significant. LUBCO and the district are continuing to discuss the methodologies and results of risk assessments covering LUBCO's chrome process tanks. We're hopeful that this final issue can be resolved and agreement reached as to the tanks to be included in the curtailment protocol. If not, we will return to the board next week on this discrete disagreement. Thank you. Oh, one factual correction that I should make. The district mentioned that there are 10 tanks at LUBCO's facility, none of which is connected to an air pollution control device. That's not correct. 2 of the 10 tanks at LUBCO's facility are connected to air pollution control devices.
And have they always been, or is that recent?
Since at least 2009, I'm told.
Thank you. Is it possible, Mr. Foster, for you to walk the board and through your version of the stipulated order and just point out briefly where, other than Exhibit 1, where they differ?
Sure, I think that there are,
So for the record, that is Exhibit A, and that is Attachment 1.
right, so the main substantive difference is the tanks to be included in Attachment 1, which would be subject to the curtailment protocol. LUBCO's position is to have tank 14 and several other tanks included in that list, but 3 of the tanks that currently exist on the list in Exhibit 16 from the district would be taken off of the list of tanks subject to a curtailment protocol.
And which are those?
Those would be tank number 16, chromic acid anodize, tank number 25, chem film, and tank number 37, Ticermet A. And I'll note that both tank number 16, chromic acid anodize, and tank number 37, Ticermet A, are currently vented to air pollution control devices. They are the 2 tanks that are so regulated.
Okay, but other than that, I know Ms. Barrera had mentioned that there were other changes, perhaps grammatical. I'm not.
Yes, let me try and address those. Unfortunately, I don't have a red-lined version of Exhibit 16, but I believe that I can identify the very few places where there are some changes. And again, what I'm talking about is the attachment to Mr. Rossi's declaration, which was issued not to represent a stipulation, but again, to allow the board to look at what LUBCO has agreed to in modifications and adjustments to its operations and its facility mechanisms. So I guess I'm sort of talking about a negative. So I guess the easiest way maybe what I'm going to be talking about doesn't exist in Attachment 1 to Exhibit 16.
So perhaps should I just be clear and ask you? So you have stipulated to what is Exhibit 16, Attachment 1. And so, with the exception of what is on to Exhibit 16, not Attachment 1, but to Exhibit 16, the stipulation itself.
Right. Exhibit 16 other than attachment 1 to Exhibit 16.
Okay, so the proposed order that, any change, any differences in the proposed order that is attached to Exhibit A is irrelevant, with the exception of the attachment number 1.
I would like to mention 2 proposed changes, and I'm not sure if they fall within the realm of editorial as opposed to substantive, but just to go on the record and talk about these 2 suggestions to change what is in Exhibit 16, other than attachment 1.
Why don't we do that? Why don't we turn then to,
And again, these are 2 items that have not previously been discussed with the district, and they were submitted in connection with Mr. Rossi's declaration, again, to give the board a flavor for what LUBCO has agreed to.
I think it would be helpful, because we're going to go off the record for a substantial period of time to review all of these documents. I think it would be helpful if you could
Sure.
turn now to Exhibit 16 and let us know what those proposed changes would be, with the understanding that the district has not reviewed them and not agreed to them, but just so that we are aware of what LUBCO is wishing to propose.
Sure. So if you turn to Exhibit 16, paragraph 7,
What page is that on? Is that on page 6? Oh, sorry.
hold on, I'm switching back and forth between 2 versions. Let me get Exhibit 16 open. Yes, page 6. LUBCO proposes to add language at the end. Now I've lost my place again, I'm sorry. Yes, okay. So paragraph 7 on page 6 of Exhibit 16. At the end of current paragraph 7, which is on line 21, LUBCO proposes to add the sentence, "The district shall notify LUBCO of all air monitoring results immediately upon the district '(S) receiving the results from its laboratory."
Could we please request him repeat that once again?
Absolutely.
Yes, slowly, please.
Sure. Again, this will be a new sentence at the end of what is current paragraph 17 on page 6 of Exhibit 16.
It's paragraph 7, right?
Sorry, paragraph 7 on page 6 of Exhibit 16. Bingo. The sentence reads, "The district shall notify LUBCO of all air monitoring results immediately upon the district '(S) receiving the results from its laboratory." Next, okay. Can I move on to the next proposed change?
I think we got that.
Okay. Now go to paragraph 15. And it's at the bottom of page 7. The current sentence begins, "The HEPA filters used." And the proposed change is, "The HEPA filters used shall be individually tested by DOP," and here's the change, "or," these are all caps, "IEST dash RP-CC007. And the purpose for that change is we've been informed by the manufacturer that the DOP test is no longer the current standard, and the IEST test protocol has replaced it.
I assume that is explained in the declaration, is that correct?
No.
Okay. Okay, we would probably need some evidence on that, but I'm going to allow we won't do it now, obviously, and I'm going to let the district consider that before we even get there, but Ms. Barrera?
Yeah, I will talk to staff about both of those. Two comments. I think this gives you a flavor of how these negotiations go and how detailed they get. And I just want to point that out because they take a lot of time. We take a lot of time to get this product to you. And we've been working very hard to do that. As to these two changes, I can talk to staff. As to the notification one, it is my understanding that we notify facilities as soon as we possibly can to when the results are available. As to whether or not we could notify them upon our receipt from the lab, there is a QA/QC process that goes on, and so we can probably work out something that will give them a little bit more comfort that they are getting them as quickly as possible. But I need to talk to staff on that. As to the other suggested change, I'll talk to staff. To me, it sounds like it's something that's appropriate, but again, that's ultimately a staff call.
Okay, thank you. Dr. Lerner,
Could we repeat the sentence again, the insert?
yes?
Yes.
Thank you.
So right now, you would add after the letters DOP in paragraph 14, or all caps IEST dash RP dash CC007. And again, that change is designed to make sure that the current standard for testing is what is being used. That same insert would also go in paragraph 15, immediately after the letters DOP.
I thought that wasn't the first change in paragraph 15. Is there another paragraph that we should insert that into?
Yes, paragraph 14.
14, I'm sorry.
So it's 14 and 15.
Okay.
Identical insert immediately after the letters DOP.
Yes, Senator.
You're offering a lot of changes, a lot to read. Is there any objection to suggest that they have a blue line of what he's recommending in terms of the changes for next week? What he's recommending compared to what's before us?
That's why I'm asking him to go through this now, because it doesn't seem that there are substantial changes, and these are not changes. These are actually proposals by LoopCo, which the district will be considering and hopefully being able to speak with staff, Ms. Barrera will, when we all take some time off the record for at least an hour to review all of the papers. And when we come back, we'll have a better idea of where the parties stand.
Well, because with how the district want to address that issue, it's a lot of to be considered, and it's technical, and it may be something that they want to spend some time considering. If that's the case, it seems to me you want to have a blue line, so it's written out and clear, not based on whether or not somebody took down the changes accurately or not.
If the district agrees to the changes, we will make sure that it's exceptionally clear to the hearing board. Is that sufficient?
Yes.
Okay, the next proposed change is in paragraph 16, which is on page 8 of Exhibit 16. And the change is the current sentence reads, Lubco shall not clean the roof or do housekeeping. And we propose to insert in that sentence the words, other than its current housekeeping. So again, the third sentence of paragraph 16 that begins, Lubco shall not clean. After the word housekeeping, add the words other than its current housekeeping. Which we hope removes the ambiguity of what housekeeping can continue to be done, which obviously Lubco intends to do. Next proposed change is in paragraph 9. The second sentence currently reads, these tanks shall be removed from the premises within 60 days. Lubco proposes to replace that sentence with the following. The contents of these tanks shall be accumulated and removed from the premises within 90 days in accordance with applicable hazardous waste control laws.
Please have that sentence repeated.
Yes.
Of course. The contents of these tanks shall be accumulated and removed from the premises within 90 days in accordance with applicable hazardous waste control laws. Lubco also proposes to delete the sentence that begins within 15 days and replace it with the following language. Lubco shall file a permit application to remove these tanks from its permit in conjunction with the applications associated with the implementation of the district approved risk reduction plan. Read that one more time. Lubco shall file a permit application to remove these tanks from its permit in conjunction with the applications associated with the implementation of the district approved risk reduction plan. two more changes. Paragraph 10, same page.
I'm sorry, Dr. Lerner needs that one once more,
Three's a
please.
charm, thank you.
Lubco shall file a permit application to remove these tanks from its permit in conjunction with the application, plural, associated with the implementation of the district-approved risk reduction plan. Ready to move to the next one?
It seems so.
Okay. Paragraph 10, Lubco proposes to replace the current sentence with the following sentence. Lubco shall cover with plastic and shall turn off the tank heaters for any tank containing hexavalent chromium not attached to an air pollution control device when not in use. Again, Lubco shall cover with plastic and shall turn off the tank heaters for any tank containing hexavalent chromium not attached to an air pollution control device when not in use.
Madam Chair,
Yes, Senator.
this, in my view, can be considered negotiating the stipulation, and the district will agree that they can write it down and have some of their staff review it. Will it come back to us as the mock-up, yes or no? Would they agree, would they disagree?
Yes.
Thank you.
Okay, yes, but Senator, the reason why I was asking for this to take place first was both so Ms. Pereira and Ms. Pruitt can have those proposed changes, but also so that we as board members can consider them at the same time that we're reading the declarations, because we're not going to have a second opportunity to read those declarations. Well, we could if we needed to, but it's better to do it this way.
As long as I get the mock-up, that's okay by me.
Sounds good. Mr. Foster, go ahead. You had one more.
One more. Paragraph 11, same page. Line 12, it currently has 30 days, and Lubco proposes to change that to 90 days, 90. So the sentence will read, in addition, within 90 days, Lubco shall install an industrial curtain, etc.
Thank you, Mr. Foster. Those are all the proposed changes for the district to consider?
Correct.
Okay. Before we, Ms. Barrera.
I think I can safely say that I am not going to have an answer today on those changes. I'll be honest, I'm a bit annoyed that so many changes are coming at, this time. I do see a lot of them as, perhaps non-substantive. The last one is certainly substantive. But I will not have an answer for you today. Okay.
And is it, Mr. Foster, is it Lubco's position that although the stipulated order had been discussed, as was proposed in Exhibit 16 by the district and agreed upon, that Lubco will not agree to it without those proposed changes?
We may, as I mentioned in the pre-hearing telephone conference yesterday, there was not an identity of language between LUBCO's proposal and the district's proposal. And I apologize, I did not realize that we were going to be moving onto the track of getting a stipulation agreed to for everything other than the process tanks to be included in the curtailment protocol. So there was absolutely no intent to ambush or surprise, but rather, again, we presented this in connection with Mr. Rossi's declaration in the form of what LUBCO has agreed to, changes and modifications to its processes, et cetera, to resolve this issue. So it may be that there could be some additional discussion on these points. Frankly, we do consider them to be relatively minor in the scope of the stipulation, but I don't know that I can sit here and say right now that we could withdraw every one of those proposed changes that I have listed for you.
Okay. We're going to take some time for the board and members of the public to read the declarations and go through the exhibits along with the declarations. Ms. Barrera, Mr. Foster, is there any amount of time that this board could take that would lead us anywhere closer to discussions among the parties with regard to the proposals or discussions with staff? Let me start with Ms. Barrera.
I don't think so. I mean, I don't know if it, we won't resolve these issues today. As I mentioned, it may be that most of them are non-substantive and we're, not a problem, but I can't say that at this moment. I don't think that the suggestions which have been made on a big picture level should stop the hearing and public testimony from going forward today. Certainly, there are, when you read the order, there are big picture conditions that will reduce hex chrome at this facility. They are removing tanks. They are installing their immediate short-term measures, by moving things into spray booths vented to air pollution control equipment, demasking operations into spray booths. They are going to submit, they're willing to put on air pollution control equipment. We want them to actually submit a plan to us so that we could look at those. Typically we might have put some of those things actually into the order. Instead, we've asked them to submit a plan on how they're going to connect all this equipment to air pollution control equipment, because we need more time than we've had to evaluate those applications and make sure that the specific things that they are proposing are appropriate. I will say that rulemaking is underway at the agency with respect to the chrome facilities, and so and there's technology reviews separately going on. So we want a plan. We want their proposals to connect the tanks to air pollution control equipment to come in and we want more time to look at it in the context of everything else that's going on. But there are, again, if you look at this order, there are things that will definitely reduce hex chrome emissions at this facility and are of benefit to the community. But again, on these new changes, I'm not going to have an answer for you today. I do think we can proceed with public testimony, and then we're going to have to put the rest over till next week. It may be that, I know we talked about perhaps coming back next Tuesday to continue this. It may be that perhaps Wednesday is a more appropriate date. So I would just put that out there.
That seems appropriate to me. Before we go off the record, I don't see any speaker cards have been presented to the clerk. We do have, let me mark it first, we do have one email that we received from email address anna@zavarimport, whatever, I can't read it, .com today at 9:15 a.m. We're going to mark that as public exhibit number 1. But let me ask right now, before we decide how to proceed for the day, whether there is any member of the public who will wish to be heard today. If there is, if you can please raise your hand and let us know. I'm not seeing any. So I'm thinking at this time, perhaps we should discuss when we should adjourn to for next week, and that will allow hearing board members ample time to review the documents. Mr. Camarena.
I have a previous trip planned. I will be absent on Tuesday.
Thank you. It sounds to me like the parties will be more prepared on Wednesday, even though we had originally discussed Tuesday as the day to come back. Is that correct? Ms. Pereira has indicated that that would make more sense for the district.
I believe it does.
Okay.
I believe that makes more sense for everyone involved, the district, LUBCO, and the board, to go on Wednesday.
Okay.
And I know you'd wanted to reserve 2 days, but I don't know what the calendar looks like for Thursday.
Thursday is now more open. I believe we have one matter on consent and the hearing board general meeting, which leaves us wide open.
Okay, so if necessary, hopefully this could be concluded on Wednesday, but in the event, I guess I would ask you that you not schedule anything else for next Thursday.
We will save the day, both Wednesday and Thursday.
Okay.
Okay. Senator.
Right, Ms. Barrera, since we're coming back next week, it would be advantageous for me to know there's a photograph taken of the ceiling fan, which exhausts pollutants into the atmosphere. You've got a lot of photographs, but that one is not included.
I do not have a photo of that. I will see if there's one available, or perhaps LUBCO can bring a photo.
I'm sorry, you're a ceiling fan?
You have a ceiling fan that just disperses moves the air around. I think you got an aperture opening in the ceiling. Is that not correct?
There are historical equipment on the roof with a fan. I'm not sure what your source of the information that you're pulling from that indicates that there's a fan on the roof. Can you be more clear?
I thought it was a fan inside.
Well, they have spray booths that have fans with them. But did you see this image somewhere, or?
It was discussed in one of the reports, the inspector report, that there's this fan inside that moves the air around inside.
There are evaporative coolers that bring air into the facility. There is a roof-mounted fan that's not in operation. It's been disconnected, so maybe that's the fan that they were referencing. I don't know. I'm speculating. I haven't
So
seen
there's
the
no
report.
fan that causes the air to be emitted into the atmosphere?
No.
I think that he's referring to the declaration of Beverly Caldwell.
That's right.
Okay, I haven't seen that declaration, but I'll review that, and we'll look into that.
Thank you.
Thank you. And also, if the parties have achieved agreement on prose language, as the senator requested, if we could have a red line version of a new proposed stipulated order, if there is one, that would be very helpful as well. At this time also, I want to ask, since we're going to be reviewing and hopefully deliberating on Wednesday when we reconvene, would the district like your exhibits and including the declarations to be in evidence?
Yes.
Any objections, Mr. Foster? Okay, and same, Mr. Foster, would you like Exhibit A to be in evidence? Any objections?
No objection.
Okay. All of the exhibits then are in evidence. Are there any other matters that we should discuss before we adjourn for the day?
No.
Mr. Foster, any other matters? No. Board members, any other matters? Okay, so we will continue this case to next Wednesday. What's that date? The 23rd of August at 9:00 a.m.
Thank you.
Okay, we are adjourned. Thank you. Any other matters, board members?
We can go home early.
Okay, we're adjourned.